Hello? Please, 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 please. We are totally behind time. If your neighbor is speaking, please help me call them to order. Or we are going to do what the speaker did yesterday and kick them out of our summit. Okay. Please welcome back to this session. Let's settle down. Let's settle down. I'm humbly requesting that we settle down so we can start. Okay, so we just had a session on what practitioners think and their professional bodies. And I think that has been a wonderful session. We want to move to the session now, which is on emerging issues from Kenya and across the globe on resolution of land use disputes through mediation. Please, if you're still speaking, let's keep quiet. Let's settle down. Now I start calling people out, huh? And yes. People at the entrance on my right, please let's settle down. Okay, thank you so much. So this session will be moderated by Justice Anne Claire Williams. Let's appreciate her as she comes to help us moderate this session. Just to rehash, this session will cover emerging issues from Kenya and across the globe on resolution of land use disputes through mediation. Please let's settle down, especially if you've just come now. It's only fair that you allow us to proceed. Okay, thank you so much. So over to you, Justice Anne Claire, for about 1 hour, 30 minutes.
Habari Asabui. Yeah, it is still morning. Good morning. Good morning. I need a little more love. Good morning. So we have a group of panelists today that I think you will learn a lot from. We are going to talk about emerging issues, opportunities, and challenges. And I'd like to first call to the stage your own Justice Fred Nyangaka, who is in the ELC court. And then Stephen Langu from Zambia, a practitioner who you've seen before and one of our trainers. Victor Baba, Weinstein program manager and also one of our trainers for the last 2 cohorts. We have from Parliament in Uganda, Lucy Akello. And finally, Justice Andrew Kawuka. Did I say that right, Justice? Kawuka? All right, if you could still join us on the stage. So we're going to get started, but like, why didn't anybody say, I look like I shouldn't be retired? Yeah. But anyway, we won't go into that. So first, Justice Fred, we've heard about how the ELC court has been encouraging the parties to go to mediation. And in fact, the sense I have is that all the ELC judges and justices send people to mediation. Can you share with us what your experiences have been, and particularly when people are reluctant to go and say, hey, there's no way this mediation will work? How do you respond, Justice?
Thank you. It's an interesting question. Should I eat the mic?
Yes, eat the mic.
All right. It's an interesting question. All right. I hope now this is not edible. So yes, indeed, we often get these cases where we would wish to refer the mediation, but then they sort of stand on. Thank you, my Lord. So they sort of are hesitant. They are not willing to go, and so it poses a challenge. But luckily, many of us, the judges here, actually have been trained on mediation. Perhaps one or two may not have. So I have often used the mediation skills without necessarily reminding them that I am a mediator. So what I often do is to try and make them comfortable, even as they approach, their matter.
What do you say to them?
So first of all, I greet them. Just welcome to the court session and tell them I have read their pleadings. I have even read their statements, because we often prepare witness statements in advance. And I tell them I have looked at the issue. It is an issue that can be easily resolved without going through the entire court process. And then I ask them, what do you think about it? Don't you think it would be easier, it would make it faster for you to resolve this problem? And yeah, they do. Some do, but others say, I am not willing to see eye to eye to this one. But then that is the best we go before I refer them.
And then if they say they don't see eye to eye, do you say you have to go to mediation, or do they have to agree?
Right. I then, of course, give them the alternatives that we would consider best. And one of them, which I often emphasize on, is the mediation, because I try to give them in just a few sentences, 1, 2 or so, about the advantages of mediation, and give them the bigger picture. But you see, this is perhaps an issue which they will even actually die and leave it going on here, or leave it to their children who will be fighting later without understanding the genesis of it. So I try to give them the bigger picture and tell them, perhaps this is the best solution that could come your way. But I'm giving you an opportunity, but it's not compulsory.
It's not compulsory, but
Yes.
you have talked a lot of litigants by
Yes.
using this approach
Yes.
into going to mediation. And can you share with us some success stories, of parties that were seemingly reluctant to go, but you sort of talked them into going, and whether or not some of those cases settled? Because we're in the land court, very emotive cases. Share a couple examples with us.
Thank you, Judge. I have a number of cases, but since I don't want to drum for myself, I'll give 2 cases that have been resolved in my court, and give 2 others that have been resolved by my sister and brother judges. So I just want to start with the latest. Last month, on the 7th of February, no, that is now last month, but one. I am still a month behind. All right, so on the 7th of February, I received in the CDS case tracking system an injunction. It was to stop a burial. This party says this person wants to bury the mother on my land. So, and they are burying tomorrow. So kindly issue an injunction. Of course, I looked at it, and yes, I issued the injunction, temporary. But I looked at also, I empathized with the one who had lost the mother. So I've issued an injunction. It's going to stop the process. But then I asked myself, what if before I give the detailed directions, all right, I will give them, but before they come for them, what if I asked them to come to court earlier? So I gave a mention date. This was a Thursday. I gave a mention date for Tuesday the following week. I told them, okay, I've given you all this, you will do for 21 days, of course, and your application will be done, but let's meet on Tuesday. So then come Tuesday, they served they came. And I did the usual that I've told you. I just asked them about this and told them, look, you are neighbors. I have looked at your pleadings. You are saying this plot, this are residing on is yours and it should be interchanged. I mean, you should just, flip it over. Is that the position? He said, yeah, this one. So they talked a bit, and I asked them, supposing I referred to you to somebody who can assist you to agree, don't you think it would be easier for you and faster? See, they said, yes, we could try. And so I told them, as you do the other directions, as you follow, let's just have a mediator. So I gave them up to the Friday, that was just 3 days later. I told them, if you wish to come back, come back. If not, come back on Monday. That is just a week now later. So they tried to agree and they somehow did not. But the long and short is that on the 25th of that month, the mediator had settled the whole case. The burial took place actually that same day. They recorded a consent and they're done.
Yeah. And so I think one of the emerging trends, and I'm going to ask you about the second one, is I think now the judiciary says that they have to take a more active role. It is not just saying, I'm referring you to mediation. Very similar situation in the US, because mediation didn't take hold at the beginning. It took us many, many years. It took years to convince the judges. The judges had to be trained, but we realized we had that responsibility. The other thing is, Justice, you showed your humanity when you sympathize with them. And I know when we wear the black robe, we have that symbol of authority, but the litigants, the parties need to know we are human beings too.
Yes.
And showing that empathy. What was the second case you're going to share?
The second case was in Kitale. I have just been transferred to Migori and Homa Bay at the beginning of the year. So in Kitale, there was this situation where 5 children who are of a sister to the brother, so that's just an uncle. They were disputing over ownership of land. The mother had been married sometime, and she passed away the other side, but the family became hostile now that they didn't have the mother. They said the father married another lady after that. And so the children come back home to their mother's place, but their uncle says, this land was left to me. They come from West Pokot. And the children are saying, but the Constitution entitles us to have at least a bit. We have nowhere. Actually, the children were staying in a shopping center by the time they filed the case, but the uncle didn't just want to hear about it. So I gave them my perspective just softly. I told them, look, welcome. Why can't you say hi? Hi to each other? Because they sat at the far ends of the court. They said, but our uncle doesn't just want to see us. And one of them, the youngest, was actually in class 5, a young girl. So I asked the uncle, what about this? These are your children, basically. He said, yes, but they have a home elsewhere. I said, okay, fine. But what if you understood that the law permits them to have, a share, very small or enough, at least where their mother hailed from? He said, no. I told them, let me just send you to somebody to help you look at this. He said, no. So the children said we would be willing to say hi to our uncle. So actually what I did is I took out my 2,000 shillings. I said, you children, go look for a place where you can have tea with your uncle, right? And uncle, please ensure this 1,000 shillings, you buy tea for your children. They are your sister's children, if you don't have resources. So they went home. It was heated. But I told them, after you take tea, you go to the mediator, right? They did not actually before the mediator. But after the mention, which was about 3 weeks,
But it's not even, I don't think his is on. It is, okay, go ahead. It's not trying. That is.
all right, so thank you, sorry for that. So when they came after 3 weeks, they said they didn't meet because the uncle didn't want to meet them. I told them, fine, just go to the mediator. Uncle, where is my money? I just used that. Where's my money? I mean, you should have used it. At least even if you didn't want to meet your children, you should have used it. Give it to me. He says, no, I used it to buy other things. I said, okay, I've forgiven you. Just then go to the mediator. So the mediator took them through in 1 month to court. And what I remember most is that the young girl is the one who said, I want to say hi to uncle. I said, just go on. This is a court session. She crossed over, shed tears, and they hugged, and they went home peacefully and happily after that.
Yeah, isn't that
Very
amazing?
interesting one.
And so, did you finish that one? Because
Yes,
I don't
no,
want you
that
to
is-
go to, let's hold off for a minute before you go to the next two of your colleagues, because I want to turn to Justice Andrew and ask him about his approach and what he has done when he brings a group in for mediator, because he is also the head of the Judicial Training Institute in Uganda, and he has many other roles, which we'll talk about in a moment. But share with them what you have done, Justice.
Thank you, Judge. I just want to pick it from where the Honorable Justice Fred Ongora has left it. I like his last point of creating a conducive, mediatable environment. I think the success of any mediation lies in a conducive, mediatable environment. So when he gave the children money, he was bringing these children closer to the process. The uncle to the children got to appreciate that, look, if the court has this goodwill for these children, then who am I not to into this process to have this mediation to a conclusion? Now, what do I do? Before I mediate a case, I have to understand who my clients are. Just like the banks always say, KYC. Know your client. I read the file. If I discover that, for example, these are two Kikuyu fighting each other, I will do a lot of reading around the Kikuyu custom and Kikuyu dispute resolution processes. For us in Uganda, if I asked Justice Ocheng to walk like a Kikuyu or a Kamba, what I mean is for him to tell me his lineage. So he'll be able to tell me his lineage. I'll probably be to questions around his custom, around his dispute resolution, mechanisms around his custom and where he comes from. And chances are, if Justice Angote and Justice Ocheng are Kikuyu, and they are telling me about walking like Kikuyu, telling me about their cultures, telling me about their customs, there is a high likelihood that they will touch the Kikuyu dispute resolution mechanisms. And if I speak Kikuyu, I will speak in Kikuyu. I will not speak English. Now, from where I sit as a judge, I mediate cases. But when I am mediating cases, I move away from my judicial seat and sit the other side and tell the lawyers and the parties that I am not in this as a judge, and kindly don't refer to me as such. Don't refer to me as such. And you know, judges, that being referred to as my lord is very nice. But if you want to close a mediation, kindly consider standing over that being referred to as such. But having read this file, I have gone the other side. If you came to my office, you will discover my clerk boiled some water. There are some tea bags. There's sugar. There's a bunch of bananas. There are some bottles of water. As soon as we begin, Justice Ocheng and Justice Sangote to walk like Kikuyu, I try to find out where they have come from, what time they set up in the morning to travel to court. And because I've done a bit of reading around them, I am able to probe certain questions. Before we go into the discussion, I invite them for a cup of tea. And I lead the cup of tea journey to the table. To the extent that in some instances I will serve the tea to them. I will serve the tea to them. It doesn't take away anything at all. It doesn't reduce me to anything. And the moment I do that, quite often somebody will come to me and they will touch me and say, Judge, may I have a word with you? And I'll say, no, don't refer to me as judge. You remember? And then I'll tell these other members on the team that, look, he wants to have a word with me. She wants to have a word with me. Kindly, may you allow me have a word. That is to enable them get to appreciate that I am not being biased by this person. And then when we go, they will tell me so many things. And the process of telling me those things, I will ask them, among the things they are telling me, which are confidential, that they wouldn't want me to share with the other party. And then I would be able to share that with them. So on a number of occasions, I have closed the mediations fully, I have closed the mediations partially, and I have failed closing some. Now, for us in Uganda, the CJ has issued a practice direction on remuneration of mediators. So we have a fully concluded mediation. This is where the case is settled fully. The payment to a mediator is about $90 US. We have where cases are settled partially. It's about $40 US. Partial settlement is if the issues are 7, you have settled some of the issues. Then the issues that are going to trial are just a few. That's a partial settlement. A failed mediation, we also pay for it. I think it's about $25 US because a lot of effort has been put in. But then there are those mediations where we pay up to $200, $300 US. Those are mediations that I have personally followed through because in addition to my role as head of training, I head the ADR and AJS docket in the judiciary. So my registrar's role is to identify those heavy mediations that can even take 3 months, that involve a mediator traveling so many kilometers from Kampala, maybe 200, 300. So we compute the costs around it, and we treat those as special cases. For now, that's what I would want to just share with you.
And so that is important for us to know how they handle it. And then thank you, Justice. Again, a sample of the humanity, showing it sort of like my daddy said to me when I went on the bench. He said, never let your black robe get in the way of your humanity. But for the grace of God, you could be right there in the street homeless. And you have to let people feel that empathy. And you know that a lot of people that come to you coming from very far away, and I think you shared with me, I'm going to move to Victor, but he also shared with me when he knows people are coming 2 or 3 hours away, they're poor people, it's been very difficult. The court provides money for the parties to get back home. That is innovative. That is very innovative. Victor, you work in the camps in Sudan, in the refugee camps. And so before we get into other issues, just sort of share how you're able to manage, because these are people who have been warring. I mean, they're there in the camp, they're mad, they fight over space in the camp. Right. Give us an idea of how you are able to be effective.
Hatujambo. Hatujambo. Thank you, Judge. Judge, you actually picked words from my lips, because I was just about to say that the foundational stone of every mediation begins with an act of humanity. The foundational stone of every mediation begins with a single act of humanity. A single act of humanity communicates goodwill to the parties. A single act of humanity signals to the parties, or disputants for that matter, that you truly care about them. And this is very important. It's important that we let the parties know that we genuinely care about what they are doing. And so this is very important. One of my pre-mediation ritual is always humanity. And humanity is anchored on compassion. So sometimes I take a lot of time just to communicate to the parties that I'm a human. And sometimes our justice systems are system-centric. Think about it. Our traditional or mainstream justice system. Sometimes it can be system-centric. By this I mean technicalities and all that kind of stuff. While when you look at the art of mediation, there's a human face to it. And so I always try as much as possible to humanize the process. I reduce myself to a human being,
So
because
what do
that
you
is
say?
a genesis.
So Victor, so give us an idea. You're saying you humanize. So what do you say?
Right? Sometimes I'll actually go to a restaurant and eat food that is their best delicacy. Right? And what that does is that they accept me. They don't see me as a foreigner. Because some of these people have been through a lot of stuff. And they have insensitivities of outsiders. And so many a times I try as much as possible to reduce myself to where they are, for lack of a better word. So I try as much as possible to be an outsider and an insider simultaneously. And sometimes to do that, you have to spend time with them in their homes. Sometimes I'll go to their homes and just tell them, tell me your story. Speak to me about your family. Tell me what you've gone through and so on and so to speak. And while I'm doing that, I'm laying the ground for them to trust me, for them to, goodwill, for them to see goodwill, and for them to see that indeed I am a neutral and an impartial party.
And these homes you refer to, these are the tents or the shacks that have been put up on the border,
Right.
and you take yourself there.
Right.
So they can see that you have a heart and you understand. So I wanted to share those techniques first as we sort of set the stage. And I want to turn now to what is going on in different countries. And we had heard Stefan, Judge Mugeni. Stefan's in practice for himself. He's a trainer. He's with Weinstein International Foundation, just like Victor is. I sit on the board of Weinstein International Foundation. I did not need to do another thing in my life, but Weinstein helps mediation in developing countries, and I knew if I joined the board, I could help Africa. So that's why I joined the board. And Victor is one of our fellows, and Judge McGinney mentioned that, Zambia has been up and down, up and down, up and down. So it's presented a challenge. And with you as a lawyer, you were very skeptical of mediation. And we went through 2 trainings and he became a true believer. And he and Lois are now in their own mediation company. But tell us, Stefan, with that kind of challenge, what's been the strategy that you've used to try to have mediation grow in Zambia?
Thanks, Judge, and good morning. I didn't realize that Judge would tell my secret, but anyway, it's out there. Yes, I think Judge Mugeni at least outlined what we're going through in Zambia at the moment. And so what we've decided to do, certain times, if the cow can't come to you, go to the cow and get the milk. So what we've decided to do now is to create strategies to try and see how we can promote mediation, how we can jumpstart the process of mediation in the country. And thanks to some of the interventions that have been going on, we've come to Kenya a number of times. Believe me, we've gotten some of the ideas that Kenya is doing, and we've told ourselves this is what we're going to do. So when we got here, we realized that firstly, commercial mediation is actually being implemented, and there are certain instruments that had been put into place, like SIs, and we got the SI, started the SI, and we said, first thing first. We created, came up with a paper that we shared with the Chief Justice. The Chief Justice is happy. I sit on the advisory board of the Chief Justice in ADR and backlog cases. I think the Chief Justice doesn't know that I was part of the people that prepared the paper that went to his office. So he sent the document to the committee, and the committee gave me that document and told me, can you do a paper to convince the Chief Justice? So that is the first thing that we've done. So we're doing that paper, going to the Chief Justice. If approved, which I believe is going to be approved, private mediation for the purpose of enforcement under the ambit of the court annex mediation. So that at least will give legal efficacy to private mediation, because there's a lot of private mediation that is going on, but the biggest problem has been enforcement. And so when that happens, it's going to at least give us an interim relief in terms of how mediation is progressing. The second bit is the Arbitration Act is undergoing amendments. And so we told ourselves and said, if we lose this opportunity, because the Arbitration Act is undergoing amendment, it's not coming up as a new law altogether. But if we're to come up with a mediation act, it will take time, because just to get an act enacted, a lot of things that happened. So what we've done is we've created a portion in the Arbitration Act that deals with mediation, from initiating mediation right up to enforcement. And in it, we've also incorporated the aspect of private mediation. And we've convinced the Law Development Commission to include it and to change the act from being an arbitration act to being an alternative dispute resolution act. That has been accepted. And we are, I think, going into finalization, because now we're discussing with stakeholders, other stakeholders. And the other reason we decided to do this is because there's this very nice hype in the country of everybody seems to be speaking arbitration and including the president. So everybody wants it out. So we know that if we include the aspect of mediation, sooner than later we will have a mediation act embedded under the Alternative Dispute Resolution Act. That is the second thing we've done. The third thing that we've done, now this is a process to try and enhance court annex mediation processes, is that we've done a paper that we've shared with the judiciary for a collaboration, where the judiciary should give us, because there are a lot of matters that are going on for mediation. We've got a few mediators on our part, and when I mean on our part, I mean the mediation center that we've created. We've trained a number of mediators.
50?
Yeah, 50, and with this 10 that we're finishing off, it's going to be 60 soon. I should eat it. There's a new cohort that we're working with, so the number will definitely go up. We've told them, we've given them a position where we are saying, can we help and assist you with, firstly, coming up with a proper mechanism on how we'll be dealing with matters for mediation, sort of create a registry outside, and the judiciary should allocate us X number of matters that we're going to deal with our mediators. And once the judiciary sees how we are performing in terms of meeting matters, then they can replicate with the rest of the mediators that have been trained under
Yeah,
the
because
judiciary.
one of the problems in Zambia had to do with initially the quality of the mediators. And that was part of how the court annex mediators got a bad reputation and people have not been coming. I thought it was important here because the quality of the mediators makes such a difference. And the criteria set here in Kenya has been a very high standard and has evolved. And so I also wanted to show how the impact of Kenya on other countries, because Kenya is leading the way. And I want to turn now to our member of parliament, Lucy, and I want, because Justice Ochieng, you talked about a land matter starts sometime as something really small and gets really big. And she's going to share with you a situation in Uganda that just screams for mediation. Go ahead, Lucy. She's been in parliament 10 years. Sorry.
Yeah, thank you so much, Judge Anne. Hamjambo. I'm borrowing from Victor, and if the pronunciation is wrong, just remember Kiswahili died in Uganda. So thank you very much, Judge Anne, for giving me this opportunity. For me, I am humbled to be here, and being the only member of parliament, for me, it's very, very, very good. I want to share with you our story of Uganda, very many, which happens almost every day. And that's about what mediation can do and the roles that maybe some members of parliament also can play. And I want to challenge that actually members of parliament are involved in mediations almost every time, and you need to empower them. This is a story that, this is a land conflict that started over 10 years ago, coming to 12 years. For those of you who may not be aware, I come from the northern part of the region, which suffered over 20 years of conflict. To be specific, the Lord's Resistance Army, the notorious Joseph Kony, who killed so many people and made many people settle in internally displaced persons camps, IDP camps. The government, as a way of ensuring the safety of the people, asked everybody to leave their homes and go to protected camps. I'm going to cut it short because we don't have time. And as a result, people lived in the IDP camps for over 20 years. Imagine all that time. You have left your home for over 20 years. And now, with the help of our interreligious leaders and council, they mediated. Actually, there was a dialogue, and we ended up with a peace deal where Joseph Kony left finally. And now people were asked, leave your IDP camps, go back home. And here is a government that's telling you to go back to your home. And you're going back to your home. When you reach home, you are faced with eviction. You are not welcome here because this is a wildlife reserve area. This wildlife reserve was passed by the same parliament when people were in IDP camps without consulting them, without even paying attention to the law. So from that time, that is 2012, there has been a battle between the government of Uganda and the people. And I'm talking about now, they are now, because they have multiplied, over 90,000 people affected. Because it has been taken as a wildlife reserve area, the health center, which was built by government, was closed. Mothers are dying almost every month. On average, 2 mothers are dying as a result of giving birth. Mother and child. Children being born are not being immunized. Kids are not going to school because the only school which was there was also closed. They cannot go to their gardens because they must stay alive to protect their land. Now it has metamorphosed into something now bigger, from wildlife reserve to now inter-clan and inter-district dispute. Because now another district, which is neighboring that district, that place, is saying, this land belongs to us. This is our land. So they come over, attack the people this side, and many people are in prison as I speak now for criminal, what do you call it, you judges with me? I'm not a lawyer. Criminal, now it has turned into criminal cases. So many young people are now languishing in prisons as a result of this. 4 days before, just the day I was coming here, I came here on Tuesday, there were over 700 young men who armed themselves with bows and arrows, spears, and said, we are taking this matter into our hands because the government has failed to protect us. We are going to protect ourselves, our land, and our children.
And so yes, and so I just don't want, my apologies for interrupting.
Yeah.
So as a member of parliament, your urgent request, I mean, the only way this thing can be resolved is mediation because of all the bloodshed.
Yes. Our request has been, and there have been attempts. My judge here will correct. The president set up what we call the Judicial Commission of Inquiry. About a year ago, this failed to start. It failed to kick off. We have tried to identify mediators, but every time they say this is from that side, they will be impartial. Actually, yesterday I said, how about we reach out to this great team of mediators that have been already certified internationally? Come to our rescue. Come to our rescue, and I am asking Judge Andrew here to talk nicely to Judge Anne and the rest of the teams which are here. And for us politicians, because every time we are there, they will accuse us of inciting violence. But let me tell you, we have been talking about humanity. No sane leader will sit back and look at how people suffering and you do nothing about it. I can tell you, as a leader in that area, I am not that. Every time there's a problem, what I will do, I look for people who will look for panyas. Panyas is a Kiswahili word, right? Yes, the shortcut.
Sure.
I'll look for panyas. I'll buy a blanket. Sorry. Shortcut.
Yeah, shortcut.
I buy blankets. I buy saucepans. I buy plates. And I say, can you go? Because they will burn. When they attack, they will burn their houses. They have nowhere to sleep. Children are sleeping in the rain. I say, can you send these taplings? Can you send this? But don't mention it is from me. Oh, I'm sorry, it is live. Now you have known I've been doing it. Let me tell you, the humanity in you, you will do something.
Amen.
And I am not doing it because, and there's a time I even told one of the security officers, because when we went there and they stopped me from accessing people, he said, didn't I tell you this place is no longer yours, no more votes? And I told him, you know what? You want my position as a woman member of parliament? Let me give it to you. If that is what you want, I am gladly giving it to you as long as you can give peace to my people. I have no problem. I don't even want this title. For me, what I want is peace. I want to see my mothers going to the health center and giving birth normally, just like any women elsewhere. Why should it be different for these people?
So
10 years.
can we give Lucy an amen and a woo?
Amen.
So Lucy, let me stop there, because when we talk about the issues and challenges, like we were talking about the Nairobi River, and the fact that the CJ and all the judges went to Mathare. I said it right, Mathare, or did he Mathare? Yeah, I said it right, and then I heard him say it, and it made me think of the wrong way. So, but would you share with us, and then I'll move to Justice Andrew, what has been innovative about the approach the judiciary has taken to deal with issues in the community? You know, some of the outreach that is being done that you think is that is effective.
I think one of the best things that have happened in the judiciary in regard to mediation is to create awareness. And there are a number of ways that the judiciary has done. For instance, we have what we call mediation. Okay, just last week on Thursday, we had a mediation, a sensitization day, but the week before, right, we had a mediation screening, period for 1 week. Now, so we have set up, I would say, periods and times when we create awareness to the public. Judiciary is always, at the back. We rarely go to the public like politicians would do. But when we have opportunity, we do. So those sessions we create. Then also, in the judiciary currently, we try to create awareness of various things. For instance, including the fact that judiciary is a corrupt-free, institution. So we have daily briefings. And in those daily briefings, when people come to court, one of the, like in our court, what we have done is as a standing agenda, as we tell the people, judiciary is corrupt-free, kindly don't give anything, services are free. We also remind them of the alternatives that can be to the hearings that they are going to have. And so we tell them there's also mediation, there's the AJS. Which one would you want to pick? If you have to, then see the court administrator if you are free to do that. So we create that awareness.
And who gives them that information? Is that the registrar?
It is in every court station has the judicial officer, that either judge or magistrate, okay? And also the rest of the court staff. So we have, for instance, in my station, we had assigned a judge. The judges who are there, not necessarily from the ALC, that's the Environment and Land Court, but even from the High Court and the Employment and Labor Relations, they interchange and join them on those daily briefings, together with one magistrate and 1 or 2 judicial staff. Then that's on a daily basis, so that as the people come, they know that they have the alternatives. The third way, of course, is to have radio talks, which has worked well. And I think the other one, which it is now my own, of course. Okay, there's also the court users committees, where we also synthesize, the stakeholders when they come. We tell them, look, emphasize to the community that these alternatives are available. But for me, I have used the Bible way of doing something. I have always remembered John 4, where you all read the Bible and the Samaritan woman who had 5 husbands and she thought nobody knew. And so when she met Christ and he told her, she was like, wow, who told you this? And because she was that surprised, she left her jar and went to the village. So whenever I have had a partial or full settlement mediation, and this is, I got it from the experience that in 1 or 2 sessions had been successful, the parties had come back to challenge the mediation by saying, there was fraud, or, I'm illiterate, and these people, I didn't hear what they were saying. So I discovered and said, okay, if I don't involve these people during the time we are adopting this mediation agreement, they are likely to come back to challenge it. So from then on, after I got 2 applications to set aside the agreements, I decided to always adopt it in their hearing. So I invite them when it's a full settlement, and just on day 1, when they are reporting, I ask them, did you agree? Said, okay, yes, then I'm recording. So as I record and adopt theirs and tell them, now this is your judgment, then I send them away like the Samaritan woman. Go to the highways and byways and tell them that mediation works.
And that is such an innovative way to ensure that you don't get pushback.
Yes.
And since you make them appear in court, you have not had pushback.
Yes.
Right?
Yeah, and also then they go with the good news that
The
mediation
good
works.
news, and they spread it.
Yes.
Thank you so much, Justice. Thank you. Thank you. I want to turn to Justice Andrew because I want him to share with you some of the work the Chief Justices in East Africa are doing. It is really quite extraordinary. And of course, our Chief Justice, Martha Koome, is right there in the leadership. So explain the structure that's been set up and the coalition now amongst East African Chief Justices.
Thank you, Judge. In fact, it's not East Africa, it is Africa.
Africa.
Yes. The Chief Justice of Africa convened in Kampala last year in March and agreed to establish an organ to promote ADR on the African continent. As we speak now, we have 22 Chief Justices signed up. They have established the Africa Chief Justices ADR Forum. Lady Justice Martha Koome, she is so instrumental in promoting activities of the forum. The Chief Justices agreed that they will be lead trainers on ADR on the African continent. In fact, in May, on the 23rd, they will formally constitute the ADR faculty for Africa judiciaries. And the lead trainers are the Chief Justices themselves. Now, we've been working with Pepperdine University in Malibu, California, and the Chief Justices underwent a 6-month TOT. They graduated last year at the Pepperdine University campus in Switzerland. So we already have CJs on the continent that are going to drive the process. In fact, you will agree with me that the success of any innovation in administration of justice depends on the leadership that you have. So if you have the leaders, Lady Justice Martha Koome, CJ Namibia, CJ Zambia, CJ South Sudan, CJ Uganda, training judicial officers, training mediators generally, why won't we succeed? The background to this in the meetings that we have had this with the CJs, because I happen to head the secretariat, they are saying that ADR is Africa dispute resolution.
I think we need a bigger applause than that. Africa dispute resolution. Go ahead, Justice.
In fact, they are saying that litigation is alternative dispute resolution. That's what they are saying. And they are concluding by saying the ADR, which is Africa dispute resolution, is original dispute resolution of Africa. And so there is a lot of hope that we have. And in May, Chief Justices of Africa are gathering in Kampala to discuss ADR in the settling of commercial disputes. Lady Justice Martha Koome has offered to host the second Africa Chief Justice ADR Summit in Nairobi this year. I don't know whether that answers the question, Judge.
Oh, very well. Did he
you.
not answer the question very well? Because I hadn't realized, I knew the African Chief Justices had an organization. I knew East Africa, but the progress that's been made gives us so much hope, and it's concrete, and sharing what has been, I mean, that has been, and for me, it's just like over the moon, because I think about myself and how I am just one person, and how important it is to share what is being done. I just think it's really extraordinary. And I think, thank you, Justice Andrew, for sharing that with us. So Victor, let me go to you. So now we've got Chief Justices that are training, and we've talked a lot about alternative justice systems. And one of the things that you and I have been working on is the Human Needs Project in Kibera, which has water and hydroponic farming and a bottling plant right in the middle of Kibera, and 60 farmers with 15 farms, you know, in the greenhouses and hydroponics. So, I mean, it's just extraordinary. One of the things they did not have was a justice hub, which concerned me. So when I visited it last year, I said, what happened to justice? Aren't there women that are being abused? Aren't there people who are working and their employers abuse them? And so and Justice Satati has taken a real lead in this, and Honorable Mathoni have built, we brought the judiciary in. There was a big meeting there in Kibera, and one of the outcomes also was to train community leaders. So could you speak to that, Victor, how important it is to, and that you're going to start this pilot program. We're doing this in Kibera for 10 community leaders. Could you speak to that in training?
Thank you, Judge. Just to build on the foundation that Justice Andrew has already laid, what they're doing is an up-down kind of an approach. And what we're doing is a bottom kind of an approach. And that is complementary. If we want to solidify the mediation or ADR, Africa Dispute Resolution framework in Africa, then we need all hands on deck. What I mean by that is we need an up-down approach, and we need a bottom-up kind of an approach. And that's what we're trying to do with Justice Ann, Honorable Sitati, Honorable Mudhoni, and many other stakeholders that we're engaging on this particular project. And this is special for me because most of us, when we think of Kibera, what comes to our mind is it's a conflict hub, for lack of a better word. And so here we have a lifetime of an opportunity to change the narrative, to shift the narrative. And how do we do that? Number one, through collaboration. We want to collaborate with existing entities that are on ground in Kibera. Number two, how are we going to do this? We want to build the capacity of local mediators, because they know the ground, they understand the territory, they know what needs to be done, and so on and so to speak. And number three, we want to put together a community justice system. Now, yesterday we had a panel that extensively spoke about the STARGE agenda, social transformation through access to justice. And exactly that's what we want to do. We want to transform Kibera through mediation, right? So in a nutshell, that's what Justice Ann and myself and many other stakeholders are trying to do in Kibera.
And you mentioned the ground up, and so we know what Justice Joel Ngugi is doing, and so I should also have Justice Andrew talk about his relationship there and how Justice Ngugi is sharing ideas, supporting. Would you share that, Justice? And then I'll get to you, Stephan.
Thank you, Judge. When we met with Justice Ngugi in March last year, one of the things he came in to offer to support, give technical support to Uganda judiciary to develop the alternative justice system strategy. And within 6 months, we had a strategy issued. And I want to take this opportunity to thank Lady Justice Martha Koome, who allowed Justice Ngugi to come in to give us technical support. I also recall last year, Lady Justice Martha Koome invited the Judicial of Uganda, the CJ, here. We came with the Deputy Chief Justice, who was representing the Chief Justice, to attend the 3rd AJS Summit in Nakuru. And that also helped us a lot in terms of guiding us on the framework of our policy. All that was based on the foundation that Lady Justice Martha Koome gave us in terms of the resources, the technical support that we needed. And I recall in Nakuru, we were hosted by Justice Ocheng at a dinner with the Deputy Chief Justice. And in fact, on this note, Justice Ocheng, allow me to convey greetings from the Deputy Chief Justice, Justice Richard Butera. I also recall we had a meeting with Justice Angote, a breakfast meeting with the Deputy Chief Justice in Nakuru. And he also shared a lot of information that has helped us shape the AJS in Uganda. We are rolling it out soon. But perhaps, Judge, if you may just give me a second so that I say something. From what I saw at Strathmore attending the training that you did, and from what I have witnessed in this room, with your permission, the delegates here, my Lord Justice Ocheng and Justice Angote, as the leaders in here, it would be important to allow me table to the Africa Chief Justices Forum, ADR Forum, a proposal. We have a lot of resources in here. What about making a proposal to form an exchange program of mediators so that we can have mediators from Kenya come to Uganda for a week? We plan it in such a way that the work is organized. We do online preparations with the mediators. You come and mediate some cases. I do not think Justice Ocheng, being a senior in the legal profession, whether it would offend any law for Justice Angote to come and mediate a case in Uganda. And if there is no offense, this is something that, if the congregation allows, I would table to the forum of the CJs at their next meeting. And as I said, Lady Justice Martha Koome is very key, very instrumental in driving the forum agenda, and that's why she has agreed to host the 2nd summit of the forum in Kenya sometime this year. Thank you.
Thank you, Justice. And of course, here in Kenya, there have been mediation weeks, yes? I mean, Justice Koome started that, where they get all the cases. It's just what you're saying. You get all the cases registered. You get everybody ready. They come to the courthouse or wherever they're going to come. The mediators are lined up, and they just mediate case after case. That's a very interesting proposal, and I'm sure something that will be seriously considered. Stephan, we haven't talked about sort of alternative justice in Zambia. We're not there yet in Zambia, right? Or what is being done on the ground?
You're right. We haven't done much, especially for. I think there's something about this mic that doesn't like me. But anyhow, yeah, we haven't done much. And one of the biggest problems has been. I should first this side. I think one of the things has been some of the interventions that have been going on by third parties, especially when it comes to land matters. There is this very nice habit when an investor commits an offense or intrudes on a piece of land, causes of action are taken out in the United Kingdom by certain parties. So what that does, it immediately takes the dispute away from the country, and therefore any advancement in terms of interventions by mediation are immediately killed. What is most disappointing is that even assuming, I'm not very sure because I've never heard of any judgment, a judgment is delivered in the United Kingdom, the parties that are affected, who are the people on the ground, never get much redress. I was just chatting to a lawyer who represents one of the mining companies that has currently been sued by 6,000 people, represented by an NGO in the United Kingdom. He said, if there's any compensation that is agreed upon, I mean, they say the organizations in the United Kingdom get at least 80 or 70% of the rewards. So one of the things that I didn't share with you, judges, one of the things I did is I got in touch with him and I told him, have you people ever thought of mediating these matters? He says, I must confess, we've never done that. So can we meet next week when you're back? We start pursuing and looking in this particular direction. So we've never had, because every other time these interventions tend to take this thing out.
And
But
Stefan, so here's what I want to show about Stefan, and this is what I think everybody has a capacity to do. There are opportunities that come to you, and you have to get on it. You know, you've had the training and everything, like to be flexible and to be open. Be open.
Yeah.
And it's just like when I come here, you know, I try to share things that are good and things that are bad. And I say, take a little bite, a big bite, or no bite. You take the bite that suits you. You take the bite that suits your culture. And one thing I have to turn back to Justice Andrew, and then we'll take questions. So this, some of you will recall, and Justice Ochieng, you will recall, at our first summit, one of the things I wanted included was criminal mediation, because we have seen the number of people that languish in jails, and that's across the continent. I think criminal has to be looked at through the lens of mediation, so there can be restorative justice, so that people are not serving in remand longer than their sentence would be. And there's a program that Justice Andrew started in 2014. So could you share that with everyone?
Thank you, Judge. Perhaps before I touch that, let me say something about what we saw in Nakuru when we came here for the third AJS Summit. Religious leaders, if you recall, Honorable Justice Ochieng, are very key in promoting ADR. And I think we witnessed the opening of a center in Nakuru. So one of the things we are working on with Justice Martha Koome and Pepperdine University is having a conference for religious leaders and basically discussing their role. And this conference will be sometime in June in Nairobi. I'm sure Lady Martha Koome will be able to give us the dates and where this will take place. And we are saying, what is the role of religious leaders, so that we can be able to get the Kenya experience. It will be an international religious conference meeting to discuss the role of religious leaders in promoting ADR. Now, criminal ADR. Uganda had, far way back 2014, the ratio of convicts to remand prisoners. We had 70% remandees. We had 30% convict prisoners. We undertook a study, and on average, the remand prisoners would spend in prison 5 years, on average. The cost by government on each remand prisoner is $10 per day. Remand and convict. So you are talking about $10 per day per person. But also remember that some of these people, on day one, when they were arrested for having committed offense, at police, they said, I committed offense. They appear before a magistrate, because in Uganda, we do what is called committal proceedings for a capital offense, for which a magistrate has no jurisdiction. The person is saying, you committed the offense. The magistrate says, no, you don't have to say that here. You will say it at the High Court when you have been committed. The person goes and spends 3, 4, 5 years on remand. And while in prison, he gets bush lawyers in prison, fellow inmates, who will tell them, look, just sit back and relax. the witnesses will vanish over time. So this person will stay in prison for 3 years. Mind you, government is spending $10 on them per day. And 4 or 5 years later, when they appear before the judge, they tell them there is no evidence. The DPP will issue a nolle, or the person will be acquitted after some kind of trial. They go back and perhaps begin from where they stopped. And the next thing is the courts are corrupt. The judge was paid. And what happens is the law is taken into people's hands and perhaps these people are lynched. So the prison population in terms of space, the space that the prison facilities have in Uganda was holding 500% more of the inmates. And so we wrote a concept to introduce plea bargaining. And in 2016, the Chief Justice issued practice directions on plea bargaining. As we speak now, the ratio of remand prisoners is lower than the ratio of convicts. We have more convicts, about 60%, and remandees are about 35 to 38%. Now, back home, the cost of trying a criminal capital offense, full trial, is about $500 per person. As we speak today, the capital remand is pending trial at the High Court, over 40,000 pending trial. So if we are to use the $500 per person and multiplied with the number of the cases and use the number of the High Court judges that we have about 90 to 95 High Court judges, if I may recall correctly, but they do both civil and criminal. Let's assume that each of the judges is able to conclude a case in a day, which is practically impossible. But just for assumption's sake, it will take us over 40,000 days to conclude those cases. Assuming we have the money, which is not possible, $500 per day, assuming we have all the expertise that we need on average not less than 40,000 days. Nobody has those resources, not even America. Because the US, which is the biggest economy in the world, I hope it has not changed, plea bargain 98% of their cases. So Honorable Justice Sangote, Honorable Justice Ocheng, what do we need to do if those big economies are plea bargaining and for us we are doing adversarial? And so plea bargaining has been a game changer. Fortunately enough, under the Africa Chief Justice ADR Forum, we have so far done a training of 20 judicial officers across the continent. Lady Justice Martha Koome nominated 3 chief magistrates from Kenya. I remember the name of Annie Mwangi. I forget the names of the 2 that did the 2 months plea bargain training. About a month or so ago, Stephen, we were with you in Zambia. We've put together a class to train about 25 to 30 members of the legal profession in Zambia, including judges, on plea bargaining procedures. The forum, working with Pepperdine and the Judicial Academy of Kenya, is also going to organize a similar training tailored for the Kenya judiciary. Of course, Kenya is doing plea bargaining, but the difference is, in Kenya, you don't plea bargain everything. There are some you plea bargain. For us in Uganda, we even plea bargain treason. We even plea bargain terrorism. We plea bargain murder. The difference is the processes. I'll give you an example. We have one of very prominent people in Uganda whose vehicle was scratched. He moved out of the car and shot the person that had scratched his car. The person died. The case went to trial, and he offered to do a plea bargain. What did we do? We managed this plea bargaining in such a way that the community where the deceased was from was involved. We convened a session of traditional leaders, formerly known as Matoput, and that is where the Honorable comes from. And we went through all the way. We prepared victim impact statements, prepared community impact statements, talked to the mother of the deceased, talked with the father of the deceased, got a broader picture. And guess what we settled for? A manslaughter. Get what we settled for? 3 years. Get what we settled for? The perpetrator of the offense, I think we settled for him to build a school in that area. And so many things. That takes us to the question. Administration of justice is for who, Justice Ochieng? If I am the mother of the deceased, and I have settled with the person that killed my son, I am the father of the deceased, we have settled with the father that killed my son. The community leaders, the leader of the Acholi, presided over, the traditional leader of the Acholi, presided over the process. We put everything together, the rule, we put everything together, and we went before the judge. The matter has been settled. The man served the sentence, is back. He's a very close friend to that family now. So what would have happened if we would have done a full trial, sentenced him to death? So what? So plea bargaining is a very good initiative in Uganda. Our target is to plea bargain more than 50% cases. And the innovation that we have adopted, we go to prisons and set up prisons. We set up the DPP station, we mount a tent, that becomes the DPP office. We mount tents, judges go and sit there and try the cases. We mount the tent and we call it the lawyers' chambers. So all the lawyers that are participating in the camp have a law firm in the prison facility. We go sit there for a whole week, and we are able to clear not less than 100 capital cases.
Wow.
Which if we went through full trials with the assumptions that I highlighted earlier, would never be concluded. And mind you, a person who has been convicted of a capital offense, just like misdemeanors, they are entitled to appeal. So, through a full trial, you spend money. At the appellate court, you spend money. At the Supreme Court, you spend money. You have not restored relationships. Quite often, sexual gender-based offenses, there are relationships involved. And so, it is important that as we pursue ADR and the civil, we also consider pursuing ADR and the criminal. Thank you, Judge.
I know we have moved into our overtime. I just want to turn to each person and say, if there's one thing, and I think I'll turn to you first, Lucy, because you talked about that issue, because there's another huge issue in Uganda, because I think it was when the East African, when it collapsed 47 years ago, is that right? And so two countries, Tanzania and Kenya, paid all the government workers that were owed their pension. But in Uganda, it's been 47 years since people have been compensated. Did I get that right? And so one of the things that's pending now is a bill to try to get them compensated. And you see mediation as a way, if that bill passes, for those individual claims to be resolved, because many people have died. So could you give us your one thing you think you'll do as a result of being here, besides asking us to?
Yes, thank you, Judge Ann. And very briefly, on the 5th of March this year, we managed to pass the East Africa Mediation Bill, which, by the way, other countries passed already. And this has been a lot of injustice to the employees, the former employees of the East African community first. So unfortunately, this has been returned by the president because there's some few things that need to be worked on. But even when this bill has been passed or domesticated, because this was supposed to have been domesticated way, way, way back to handle the disputes surrounding the employees who will want their pension, liabilities, and then also sharing. Unfortunately, as a country, we slept on the job, but finally it is there. Even with this act going to be in place, first of all, what are you going to do to those employees 47 years down the road who have not been paid that injustice? Will it be enough to say we are going to increase 70% to their no pay? I think it's not enough, and that is where mediation is going to come very, very strongly. And that is where I call upon all of you. And I am hoping, what I'm taking home is, for me, this forum has enabled me to demystify my fears. Because when I was coming, all I was seeing a list of judges and lawyers. I was not seeing any member of parliament. I said, now I'm going to face these tough people with their glasses looking at me like this. How am I going to speak? But I have got the most, how can I even describe it, safe space to talk about the issues. And I have freely discussed. I've even met my brother here, Judge Cheng. We even talked our Luo. I am very, very, very happy. And I can tell you, from yesterday, I have been telling people back home that I may just enroll for a mediator course very soon to also help me. And then finally, I will come back maybe next year to give a testimony of how this East African mediation bill has been passed into an act, is finally an act, and how mediation is now working out, and how the former employees of the East African community in Uganda have now finally got justice. I am coming to give that testimony in faith.
Amen.
In faith. So thank you. For me, really, this is a very big thank you. I can't say this enough. For me, it is very humbling to be here representing all the members of parliament. I don't take this for granted, and thank you so much. Looking forward to doing more, and I have learned a lot. Thank you.
Thank
Asante
you.
sana.
Asante sana. I also want, as an aside, and I know I'm on time, so you might wonder, how is it the Ugandans came to be here and to be part of the summit? So Victor had...
And just in a minute, yesterday there was a lot about clapping. Where I come from, when a mediation has successfully succeeded, we don't just clap. We will dance. We will sing. We will adulate. So, I am expecting more clapping, more dancing, more singing, and more adulations. Whoa. Thank you very much.
So isn't she something? Isn't he something? Okay, so Victor called me because I'm on the WIF board, Weinstein. He said, Judge, guess what? I'm going to have for 2 weeks members of parliament from Uganda that I'm going to be teaching on mediation. And I was like, Victor, that is fabulous. I said, do you think they might want to come to our summit? He said yes. And when I get an idea, I get on it. And so, but I want to point out that when I talk about the power we have within ourselves, we have power. We have power, and it has to do with you thinking that you can act on that power. Never let anybody tell you don't have that power. God gave you that power. There's a reason you're in this room. There's a reason you're in this room, and that is because you can shed and shine the light. You can shine the light. Any last words, Justice? Oh, I don't mean last words, but final word. And I don't know if we're going to have any time for questions, but they'll let me know. Go ahead.
Thank you. Just one take home. But before I do that, I think I have two take homes. We have converted a member of parliament to mediation. My take home from here is that for us in Kenya, I am proposing that we, through the task force, that we look for a way of anchoring the private mediation in the law in such a manner that it easily absorbs, or it's absorbed into the judiciary. Perhaps even through an amendment of the law to include a process of filing a miscellaneous application for adoption, so that then if the mediation group or members who are not necessarily of the court annexed mediation accreditation committee are not here, but they have resolved cases out there, if they could have a registry, and then through their registry, they easily link it up with our court system, we would absorb many of those cases from out there, settle them, have decrees. People will stop having fear that mediation doesn't work. Thank you.
Thank you. Thank you, Justice. Stephan?
I think my takeaway here is that where there's a will, there's always a way. And taking what I have heard and read about the Kenyan system and mediation is my takeaway. And being one person doesn't necessarily mean that I can't change one other person. And for me, that is the route that I'm taking. All I have to do is just change the next person, and then we'll get somewhere. That's my takeaway.
Thank you, Stephan. Victor?
My take home is the power of a single seed. Now, every forest began as a tree, and every tree that you see around was once a seed. So mediation is a seed that is in our hands as judges, as advocates, as magistrates, and mediators. We have got this powerful seed in our hands. And so what we do with it is very important. Let's be ones who spread the seed of mediation and change. Thank you.
Anything else, Justice?
From me, I just want to request the audience to repeat after me what I'm going to say, and that will be it. You will. It is palatable. It is palatable. It is palatable. Let's begin. Do not ask what your country can do for you.
What your country can do for you. But
what can you do for your country?
What can you do for your country? John F. Kennedy, United States. Amen. We are done. It wasn't this an incredible group? Incredible. Each in their own way, leaders, magnificent, emerging issues, ideas, and we thank you so much for listening. And I don't know my moderator, I know I'm over the time, and so I don't know if we're supposed to take questions or we're going to get them and we'll answer them later. You have to tell us.
We will get the questions and answer them later.
All right. So I hope it was worth it for everyone to hear this magnificent.
Let's appreciate the panel.
So where's the music so we can dance?
Okay, thank you so much. We have received 5 questions on this email, which we will circulate to the panelists. Some of them are very specific, who they are addressed to, and hopefully we can get that done. So we have a small gift that will be done by Judge Lady Justice Asenath Ongeri, who has recently launched a book, which is going to be part of the package given to this wonderful panel that you almost gave a standing ovation to. So please allow me. And joining this gifting session will be Justice Mugeni and Louis Chisompola. So please join to receive a gift as well. So we start with Honorable Lady Justice Fred Nyagaka. Oh, really? Okay, I don't know what I said, but Justice Fred. Yes? Perfect. Let's appreciate Justice Fred Nyagaka. Thank you so much. Thank you so much, Judge. Judge ELC. Thank you so much. Now, let's appreciate Justice Andrew. Let me not attempt to pronounce the other word. Judge of Uganda. Thank you so much, Judge. Senior Counsel Stephen Lungu of Zambia. Okay, thank you so much, Senior Counsel Victor Baba, Mr. Victor Baba of Weinstein Foundation. Honorable Lucy. Oh, thank you so much, Honorable Lucy. Honorable Lady Justice Anne Claire Williams. Thank you so much, Judge. I think that was a really good panel. And Justice Mugeni, I don't know whether she stepped out. Louis Chisompola, Lois Chisompola. Yes, but the judge had requested to give these. Yes. Okay, let's appreciate. Great. So I want to apologize for the people I misstead and the names I got wrong. I will do better in the afternoon. Yes. I missed the tea break, and that's probably why I am like this. Now, we've come to a part of the program that is nice for most people, and we want to break for lunch. Okay, so now that we have like 5 minutes, maybe we can get the mics moving, Essence, and somebody. So let's just have 2 people to tell us what their take home for today is, at least for the morning session, as they get our our lunch ready. So we'll have the good lady there and the lady there and maybe one gentleman to match the 1/3. Yes, so let's start with the good lady and keep it short, about 2 minutes each.
Today's session marks the basis of internalizing what alternative dispute resolution mechanisms can do and calls upon us practitioners to rethink the strategies of having these strategies owned by community members than us remaining in that seat. Thank you.
Thank you. Good morning, everyone. Or good afternoon. My name is Mediator Marcela Wanjiru Andanje, and today I have known that there are no boundaries in Africa. There are no boundaries when it comes to mediation. Us as mediators, when we talk about the rules, regulations, and integrity, I hear the same language being spoken by the judges. So it's just about keeping the rules. And I feel my take home today is that the boundaries have been removed. The boundary of Kenya and Uganda have been removed. And as mediators, we can kick off the boundaries of this great continent and make it the united continent or country of Africa through mediation.
Thank you so much. So there's one question for Honorable Lucy. So I think I'd allow that. It's from Director Ambrose. So if you can move a mic that side, and then we can see. And then Honorable Lucy. Maybe a guy, if you can bring the mic here for Honorable Lucy to just take the question.
This time round, I'll be tempted to remain standing. Thank you so much, Honorable Lucy, for coming to Kenya. I think you remember me. And Justice Andrew, thank you for giving eye as a second eye to Kenya, that most of the judicial services in Uganda, you depend on Kenya. Now, when you are going also back home, please go and look for us some chances for thousands of mediators here. We can donate like the way we donate our sister, not Charity, the other lady who help your people on justice issues. I have a question to my colleague then, Lucy. In 24th and 25th of October, 2023, we had a meeting with lawmakers, with IGAD, concerning the issue of refugees. As a member of an IGAD, I want to ask you a particular question. When Minister for Reliefs, Preparedness and Refugees, Honorable Engineer Hilary Onek, we had 5 pledges to Ugandan Parliament to implement. As a member of an IGAD, I want to ask you, how far have you gone with the same issue? Because we are yet to meet this year in Uganda on the same issue. Number 1 was about the returnees back home. What are the procedures? We had a proposal, 5 pledges. On those 5 pledges, I don't want to repeat because you were there. What are the steps the Parliament of Uganda has taken so far?
Thank you. Thank you very much. You have successfully ambushed me. Unfortunately, I was not part of that meeting, but I can tell you my region, where I come from, is one of the largest refugee hosting community. And we have done that with so much humanity and with so much love. But what I can do for you, Honorable Engineer Hilary Onek is my brother. I will take your concerns to him. And before I leave, I will take your contact and I will make sure all your concerns, he has answered them. So thank you very much for giving me another time to talk. You know, for us, politicians, we love the mic. So when you give us the time, we will talk. Thank you.
Okay, and maybe, I don't know whether Honorable Justice Fred would be willing to take just a quick question we saw online, and is to whether non-legal mediators can attend mentions and hearings of the cases they are mediating, and how do they ensure that consents they reach are filed. And she was giving an example and saying they reached a settlement, the consent was not filed, and the case was dismissed with cost. So if you're able to just take that to those two questions. Thank you.
Did I hear you right, that non-legal?
Yes, if somebody is not a lawyer, can they attend mentions and hearings of a case they are mediating? And secondly, how do they ensure if they are non-legal? They have a settlement and it's not been filed and the case has been dismissed with cost.
Thank you. First of all, we need to understand that once a matter is in court, once a case is in court, it is the party's case. It's not the court's case, right? So whichever way a settlement is reached, the parties are free to point it to the judge or magistrate that we have a settlement. It doesn't have to go through mediation. It doesn't have to go through ADR. It doesn't have to go through any other, as long as, it could even go through a village elder or a church member or any other organization that has brought the parties together. Actually, if we have, I wish I could have been given time to explain about the exclusions of the cases, which in Kenya we don't accept those, I would say those settlements. For instance, defilement cases, those ones are excluded, even if they reach the agreement, of course, because by law we are not permitted to accept them, we will not. However, any other case that can be mediated or settled in any other manner, it does not matter howsoever the consent gets to the judge, as long as the parties are present and consenting. Thank you.
Could I just add to that? Thank you very much. Number one, I don't know, did you come Lady Justice? Oh, sorry. First, if there is a settlement of whatever kind, the court adopts it. So we are on one page. The judge's practice is to have the parties present as he's adopting it. The reasons, very good. However, what we encourage is that the judge or the magistrate adopts it without asking any of the parties, provided it has been signed by all the parties. So you don't need to call them. What he is doing is fortifying the settlement so that there is no pushback. But if for many of us you try that, you will find a situation where one of the parties has talked to somebody who will be saying, you mean you accepted an apology as a settlement? You only accepted that. You will therefore find people taking back what they actually agreed to. So to avoid a situation where you are reopening a matter, and some you reopen on the basis of a lawyer saying, where's my costs? As if we are supposed to build in costs or fees in a settlement agreement. That's none of our business. If the parties include it, good. If the parties do not include it, remember, the plaintiff, I was about to say appellant, squeezing the mezoe appellant. The plaintiff has his or her own lawyer. Whether they win or they lose, the lawyer is entitled to his fees. Right? The same way the other side. So why do we need to build it into the agreement? We leave it to the parties to pay their lawyers. Right? So you can adopt this, but I would not encourage it. That you have the mention to ask, oh, did you really agree? You'll get a lot of pushbacks. One other thing I want to talk about, that mediation arbitration thing that I asked about earlier. As he rightly says, as the Honorable Judge rightly says, you can settle in any manner, any case you are involved in, at any time before judgment. Right? Does it have to go through mediation? No. So you may be going on with mediation, but you meet the two of you outside and you reach a settlement. You don't even have to go back to the mediator to formulate the agreement, the settlement agreement. You can sign the consent and you bring it and we record it. So, you may have in your agreement an arbitration clause. You get into a dispute. Does that stop you from talking? So you can reconcile. You can go through reconciliation. It's the two of you. Or reconciliation with a third party. Or conciliation. Okay? Now, somebody said that there is no appeal from a mediation settlement agreement. Correct. So if you arrive at a mediation settlement agreement, you cannot then say, I'm going to arbitration. For what? But if you are doing discussions, negotiations, or even mediation, but you do not settle, there is nothing to stop you from going to arbitration. Tuko pamoja? So it's not a question of which comes before which. Even if you have arbitration clause and you are before the arbitrator and one sitting has gone, you have had one sitting already. Before you go for the second sitting, you can be talking, correct? The matter is before arbitration, but you can settle it. So these things are not mutually exclusive, and nobody can stop parties from talking. That is why mediation is always so sweet, and I can dance with the MP. Asanteni.
Thank you so much, Justice Fred and Justice Fred, for your insightful words. Now we want to move to lunch. Now, it's now 1. Can we be back at 2? That's enough. That's actually more than enough time. So we can be here at around 1:50. So we can start, okay? I'm going to humbly remind us of one housekeeping rule, which was more of our request. If after your meals you can help us clear the tables, we would be most grateful. Yes, where will be shown around where you're supposed to take your plate and cups to. Is that okay? Can we bless the food? Okay, let's pray in the name of the Father, the Son, the Holy Spirit. Bless us, O Lord, and these your gifts, which you are about to receive from your goodness through Christ our Lord. Amen. In the name of the Father, the Son, the Holy Spirit. Enjoy your lunch. We see you at 1:50. Again, bring your tag.
I weren't. Oh, it has to be okay. Yes, but let it just be straight.
One, two.
Hello. It's time to move forward. So please let's take a shorter time settling in so that those who are yet to come settle in faster. Hello, 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 people. Great. So we're moving on to the next panel. We can continue the conversations after this session. And we want to move to the session we are having today. Excuse me, please. Okay, please settle down, those of us that are standing. When our colleagues who are coming in late find us unsettled, they'll just continue being unsettled. So we want to move to the afternoon panel. And this panel is going to speak to us about land use in banking and how mediation can contribute to its optimization. So this session will be chaired or moderated by Advocate Rogers Mondo. Monda, sorry. Somebody has stolen my ad copy. Yes, so Advocate Rogers Monda is going to moderate this session, and I invite him. Karibu sana. Let's appreciate Advocate Rogers Monda as we jump into this session.
Good afternoon, everyone. As you've heard, my name is Rogers Monda. I'm an advocate, and I also chair the Nairobi Physical and Land Use Liaison Committee. I have a distinguished panel. They're all made of advocates. I will start with a lady who is also my former student, Hedaya Malesi, who is an advocate of about 13 years. She's a legal officer at Housing Finance Corporation, and she's going to talk to us from a banker's perspective. Welcome. The next panelist is Victor Kahura. He's a partner in Kaplan and Stratton. He's practiced for about 9 years, and he is also an astute litigator in land, among other areas. Welcome. The last but not least member of my panel is Mr. Stephen Maloa. He's a teacher at law, a litigator for over 30 years. So we are privileged to have a wealth of experience in legal practice. Welcome. Yesterday we had a training on clapping, and fortunately we don't have any politician here, so we don't expect too many claps. I enjoy watching plays, and in plays when something excites you, you do like that. So for our session, it will be different. Welcome. Hello. To start us off is Victor. I will ask you how are banks involved in land transactions, and give us an explanation of disputes in mediation that are related to banks.
Hello. I hope you can hear me. Okay. Thank you. So my name is Victor. I'm mostly a court lawyer. So we end up dealing with a lot of disputes relating to banks. And of course, mediation is coming in to assist us in at least resolving some of them. So coming to the issue we have at hand, and that's exactly how banks are involved. Oh, it's better? How banks are involved in environment and land matters and disputes. So generally, as you heard yesterday, Kenyans are very very astute towards buying land. And as we are mostly aware, very few Kenyans, at least very few God-fearing Kenyans, buy land in cash. So banks usually come in for the financing aspect. So over 90% of the transactions we have in the country usually relate to banks financing some aspect of the transaction. And this goes not just to buying land and owning land, but it also goes up to putting up projects, putting up any sort of project on land will involve some element of financing. So once we have a bank coming in, there is always down the line, when there's a dispute coming in, the bank ends up being dragged in as a party. And looking at the kind of disputes which we have been dealing with, we will not be focusing on a lot of the usual banking disputes where there is a charge, the bank is enforcing the charge, the bank is selling the land. A lot of that is mostly covered in the commercial division, which was handled around 2 years ago in the Mediation Summit. So what we are looking at is the land use and how banks are involved in land use disputes. So to contextualize this issue, one of the first cases, one of the main cases we think about when we deal with banks in land disputes is we have banks financing multi-billion projects. And in this particular instance, I'm looking at a project we have in Marsabit. We have a wind power project in Marsabit where banks have put in billions of their own money. And eventually a dispute arose with the community, and the community managed to get a court to declare the whole process of setting apart the land unconstitutional. So we have a bank which has put in billions of shillings. The asset is the land. And then you have a court judgment declaring the entire project unconstitutional. So that's a dispute which was attempted at mediation at the first stage. Mediation failed. The court judgment declared the rights of the parties. And now we have a matter pending in the Court of Appeal where the people who own the land have gotten an order declaring the project unconstitutional. The bank who has put in billions is looking at its project going down the drain, and you wonder, in the end, if the project is declared unconstitutional, the project is demolished, who ends up gaining? So what we are seeing in the mediation is that while the community might benefit from having the land, there is also a benefit towards the project staying on the land, and now parties have to agree as to a middle ground as to how to determine the dispute. So that's one of the issues which we are having, one of the examples we have where banks are involved in environment and land disputes. And the second small issue is, of course, once we have banks having disposed of assets. So usually what we expect is that the bank will dispose of the charged land, the new buyer will come in and take over the land, and people move on peacefully. But if you look at our cause list, you will notice that banks end up appearing as a second and third defendant, because you will find that even after someone buys land, there is always a dispute as to whether you can really take over the land. And I believe it was Justice Omange who mentioned yesterday that you might, but they have to be enforced on the ground. So you might be happy, you might have won your case in court, but if there's no goodwill on the ground, if you can't speak with the people on the ground, it's going to be impossible to actually take over the land. So one of the other matters banks get involved in is once they sell charged property, how do they ensure the buyer will end up eventually getting what they have bought? And we've been finding that mediation, having to bring all the parties, old buyer, new buyer, former owner into the same room, will end up eventually bringing a more reconciled result.
Thank you very much for that response. The next issue goes to Hedaya. There is a rumor in the streets that mediation can't work in the banking sector. By the so you just want judgment. What's the role and benefits of mediation in land disputes within the banking sector? Is there any role for mediation?
Thank you for that. Yes, there's a role for mediation. And what I have seen is, and I believe it was discussed at length yesterday, that one of the benefits of mediation is you get a de-escalation of emotions, and then parties are now able to focus on the issues at hand. So most of the times you find that when you go to the mediation table and you're facing your accuser, so to speak. You're putting a face to the papers that you've been dealing with. So you find at times you're able to reach an agreement through the mediation table, but then there are times when you're not able to reach an agreement, but when you live there, you live as friends and you get to retain the relationship. And speaking from my perspective, we've had situations where we may not have succeeded at the mediation table, but as a result of going through the mediation process, the customer will come and say, I acknowledge that I owe the bank X amount. I need some time to sort out one or two things. Can we get into an agreement that we can later record a consent in court? And you find when you get into such situations, number one, you end up saving time in litigation. My fellow litigators can confirm litigation takes time. You end up saving that time. You end up unlocking money. Those who were here yesterday had Beth Karanja talking from the KBA perspective, whereby banking mediation has been able to unlock about 11 billion. When you unlock this money, you're giving your investors a return on their investment, which is a good thing. And other than that, you're able to maintain the relationship, get into new transactions with your customers. So I may disagree that mediation cannot work. Mediation works, but parties need to be willing. Thank you.
Thank you so much for that perspective. This is to the participants. Panelists.
First of all, experience. I have to admit, I have not litigated. When you draft a contract, what you're trying to achieve is that the parties never, ever get to litigation. That's the whole point of making sure that your agreement is so good that the parties will never, ever have to resort to litigation because of all the weaknesses and challenges that are posed by litigation. And I think we've gone through all of them. There's no need to rehash them. And so when you look at, so obviously mediation is one of the things that you want to make sure that when you're drafting a document, an agreement between parties, you want to make sure that it has its rightful place in the dispute resolution arrangements. Whether you start off by negotiation, then mediation, then ultimately, as the Honorable Judge Ochieng said earlier in the earlier session, you know, as you keep on escalating, so that mediation is in there somewhere. Now, I know I'm not yet answering your question, but I just felt it's important to say this, that we review a lot of documentation that has been drafted by banks. And banks they like uniformity, they like rules, they like things to be done in a certain way. And so you tend to find that some of the documentation maybe has not been updated in a long time. And so dispute resolution clauses may not necessarily have provisions that deal with mediation. And so part of our job as we review documents and try to suggest areas of improvement is to introduce these elements of formal mediation, not the informal one, you know, where come, let's talk, you know, come to the office, you know, you owe us some money, please come over, let's have a discussion. But to have a formal structured process where, you know, it's a step-by-step approach. This is how the credit guys will deal with it. if the debt has gone bad, it's not being repaid, this is the sequence of steps. We are engaging the debtor, we are trying to understand what their issues are. Can we reach an agreement before it goes really bad, and so on. So to that extent, mediation is something that I think should be completely embedded in some of these processes, the credit resolution processes. Now, the challenge, and to your question about this issue of intersection with, yes, now the only challenge with, of course, issues to do with land is that a lot of them are very hardcore sort of legal issues, right? So when it comes to things to do with ownership, titles, etc., they tend to be pretty hardwired in the legal process. And so there's some disputes that do not really lend themselves to mediation. And that is why the way I see reforms, I wouldn't really be looking so much at reforms on the land side of the equation, but reforms on the banking side of the equation, so that if you're the regulator, if you're CBK, for example, to now start addressing this issue of embedding alternative dispute resolution processes within, whether it's prudential guidelines for banks, how you address debts that have gone bad, how you address disputes, and so on, right? Maybe that's probably an easier starting point from the banking side as opposed to the land reform side. I think that's probably what I'd say.
Thank you so much for that. Hidayah, the next question goes to you. From a practitioner side, as a banker, a legal officer in a bank, what are the challenges and limitations of mediation in banking disputes?
One of the things I'd like to echo is what my senior Maloa has said. In banking, there's processes and procedures. And at times, this take time to resolve from our end. So I'll give an example. We are on the mediation table with Advocate Maloa. He runs his own company. I represent the bank. When it comes to making the decision, it is easy for him to make the decision. I, on the other hand, in as much as I have been authorized to come to the mediation, I would need to seek certain approvals, and depending on the quantum of what is on the table, some approvals may require a board approval. So you find if a mediator is not aware or does not take cognizance of such a scenario, we may end up in a situation where it feels like one party is being an antagonist, or you're derailing the Sorry about that. So it may seem as though the bank is probably derailing the process, yet we are interested in resolving this dispute because, to be honest, the sooner it is resolved, the better for us, when we can move on to other things. Another challenge that I have encountered is at times you find you end up dealing with, say, a party who believes that the fact that you've gone to mediation, now one of you becomes the weaker party. So they start throwing issues and challenges that are probably not part of the dispute and making outrageous demands, which clearly now end up scuttling the entire process, and you don't end up achieving much during that session. The other challenge I'll speak about is I think as a mediation secretariat, there just needs to be more training and sensitization, both on the mediators and parties. Parties need to know that mediation is an option, and if parties are willing to resolve, it is an option that is beneficial to both parties. The mediators on their side need to be able to understand that when they're on that table, you're dealing with two different parties from two different backgrounds, and it would be important to have a mediator who is aware of, say, if it's a banking dispute, they're a bit aware of what the banking disputes entail so that they are able to apply themselves and help the parties come to a solution.
Thank you so much for that. Stephen, in your practice, are there any instances or cases that you've encountered that you feel if these cases had gone for mediation, then they would have been resolved?
Okay, so there are two that come to mind. And so let me see if I can very quickly summarize, because one has to do with of course, the normal day-to-day lending that banks do. And the other case is one of much more specialized lending. Because, you know, banks, they can lend to you to buy a house, but they can also lend you money to build a power station, right? I mean, so, you know, the scales are completely different. But when the debt goes bad, you know, the procedures are the same. So there's one instance, a very interesting one, where the bank lends to this a family business where the old man, the mzee of the family, has accumulated wealth over time. He has large land holdings. And his children convince him that, you know, we have all this land. We can do a very good housing project on this land. You know, we can put up, you know, hundreds of houses and so on, and really, really unlock the value because the land is just sitting there. So they convince the old man. They go to a bank. The bank extends a loan of, I think it was about a billion, slightly over $1 billion shillings. The land is very valuable. I think it was, the land itself was worth maybe 2 or 3 billion. They get a loan of 1 billion. They do this, start off this project. Very good friends with the bank because, you know, it looks like it's going to be a successful project for the bank, for the family. Everybody is happy. 2020, COVID hits. The project is halfway done, or let's say 70% done. COVID hits, construction stops, any sales that had been negotiated, gone. Now, what do? There's COVID, money has been expended, the bank has already given out a big amount of money, and they're stuck. So, if you move quickly forward, you then reach a situation where now they're stuck. Interest is, you know, is climbing. The project is stuck, and the family's consultants tell them, we need another 300 million to finish the project, to put it back on track. Now, bankers being bankers, and apologies to the bankers, the idea of giving you more money after, you know, and you've told them you can't pay what they've already given you. It doesn't quite work with banks, right? So the project is stopped. You need money to finish it so that you can pay them back, but they're refusing to give you the money. And so, of course, the usual thing, they're threatening to sell the land. The family goes around, finds somebody who's prepared to put money into the project to finish it. But this person is saying, I also want security like the bank. The bank refuses and says, no, the security is ours. If you want to put your money, you look for another security from this family, but this security is ours. And it became very ridiculous. And how we came in was because we were called in by the party that wanted to put in the money. And they told us, this bank is your client. Are you able to talk to this bank? Because they're being completely unreasonable, you know. And so we actually sat and had meeting after meeting after meeting, looking at the numbers. Eventually, the bank was convinced. And they said, okay, fine. We will part with some of the security so that this money can be put in to finish the project. We sat in meetings with the head of credit, the director of this, that, and the other. But one caveat, we have to take this to the credit committee of the bank for them to approve. The credit committee of the bank is made up of senior leadership of the bank and non-executive directors. They were not given even 5 minutes in the credit committee. The land is worth 5 billion. You want us to wait another 2 years to be paid? Go and sell the property, right? And so the whole thing came to a halt, all the negotiations, all the discussions, and so on. The people who we thought had the authority to bind the bank clearly did not. We thought they would be able to convince the credit committee. Clearly, they were not able to. And so the whole thing, again, is stuck in litigation, and yet this is a classic case where a properly mediated agreement could have been reached if the bank had been a bit more flexible, a bit more open-minded. It would have actually been resolved amicably. And so, yeah, we come across these kind of things. I'll save the other example if there's time, but that's all.
There's also the issue of ancestral land disputes in banking. Would you care to comment about whether those disputes can be resolved through mediation or purely litigation, like in Kisii?
Okay, now, I don't want to say too much about this, but in my very early career, I used to do recoveries for a big bank, and they used to do a lot of lending in the Kisii, in the Kisii region. And I had the unenviable task of trying to recover realized securities in that region. And it very quickly, and this we are talking about now 25 years ago, that it was very, very difficult to realize those securities. And I was just commenting and I was saying, had we known about mediation then, it would have actually been possible to maybe talk to the debtor and say, look, do you have an uncle? Do you have a cousin? Do you have somebody you know who can take off this obligation and maybe, can acquire the property and so on, so that you avoid those sort of issues that arise around communal land, family land, ancestral land, and so on. So yeah, I was just saying that in some of these kinds of situations, mediation actually makes a lot more sense than going through the whole issue of trying to auction, putting things in the newspaper. Nobody wants to buy because everybody knows about the issues on the land, apart from the bank. The bankers have no idea what the issues on the ground are. So that was the point I was making.
Thank you so much. If you had not realized by now, I come from Kisii, and some of these issues, you cannot litigate or legislate them. But if you involve mediation from the local personnel, you'd be able to address them. There's a good warning coming in now. So the next, we've kept very good time. Victor, this is to you. Is there any hope in mediation? What is the future of mediation in banking?
Thank you. So you just mentioned Kisii, which I hadn't planned on talking about. But very recently, I was traveling and I took an Uber. I realized I'm a lawyer. I don't know how. He's working.
Face that side.
Realized I'm a lawyer, and he decided that he's going to tell me all his issues. And in particular, he was very offended at land disputes in Kenya. And in his view, he told me, nyima wakili hamjui kufanya kesi. Said matters go to court, they spend years. In Kisii tunaita, they come, they ask you, when nani amekuzia shamba, mrudishie pesa yake. And according to him, this means that all disputes are determined within a single day. So it's not exactly mediation, but the whole idea is that sometimes you have to get people on the ground to actually discuss and understand what the issue is. But speaking as to the issue of mediation, and in particular in banking, what we are looking for mostly as court lawyers who have clients to answer to is that we have a more or less informal mediation structure in the ELC division. We had an earlier pilot project in the commercial division where there was mandatory screening and sending of matters to mediation. So we are looking at a situation where courts not necessarily compel parties to go to mediation, but ask parties to at least explore the possibility of mediation before insisting on going to court. And the reason we are looking for this is because when I get a case from a client here, and we have a suit in court, we're trying to recover property. When you come back to them and tell them the judge has said we sit in a room and talk, they immediately get offended because they tell you, we've hired you as a lawyer to act for us. Why would we get a lawyer if we also have to come to court and also argue with the debtor? So fortunately, most banks are habitual defendants, so they never see the plaintiff side of things. They're actually happy at getting matters delayed as long as possible. So what we've been looking at is we have situations, we've heard of the story about if you owe the bank $1 million, you're in problems. If you owe the bank $1 billion, the bank is in problems. So we have cases where people who owe the bank a lot of money also benefit from however long the litigation process takes. So we're trying to get the bank in their best interest to also get the matters resolved as quickly as possible. And sometimes mediation is the only way to get this done. So we are looking at a bigger role for mediation bank disputes.
Thank you so much, Victor. You said in Kisii, if there was a dispute, we could be resolved in one day. But if there's no chaos, we will not be existing as lawyers or mediators. So we need to encourage them to still come to us, because the one you have talked about from Kisii, it's a threat. So we've kept very good time in our panel. We decided to donate 20 minutes for plenary. So if you have any burning issue that you wish this panel to address, this is the time. If you have any question for the panel, this is the time. Anyone with a question? Or we were brilliant? There's no question. There's one behind there. I thought we were so brilliant, so I was ready to clap for the committee.
There's a question here.
Yes.
I don't know if you can hear me.
We can hear you.
Yeah, thank you very much, our panelists. I was just concerned about the common land and the loans that are taken using the common land titles. What do you consider when you know very well this is common land, the family land that is owned by the family, and one individual at his own discretion or way out finds his way to the bank, the family realizes that the title is already in the bank and has got the loan as an individual. What do you consider before you accept the title and charge it for the loan? Because this is what's bringing a lot of breakups in the families, where we have some enlightened members of the family reaching out to the title deed and then reach you, get the title processed and have the money in his account, when others end up languishing in the tolerance of one individual.
Victor, I think this still goes...
Sorry, my name is Omanyala Richard,
okay.
And I'm a mediator.
Victor, I think you had addressed the role of mediators in banking. Would you care to comment about the process of getting a loan with a title deed? Or we give it to Hedaya because she's the practitioner?
Unfortunately, I'm a court lawyer. I only see non-performing loans.
Hedaya, would you like to comment?
Incidentally, my background is in litigation, and I actually support in terms of litigation and when the default occurs. But I'd like to assume that if that is the scenario you're explaining, then there's a probability there was some fraud somewhere or non-disclosures, especially as to when the title was being brought to the bank. I believe there was a panelist yesterday who mentioned that a majority of, titles that we get in court or that end up in court are forgeries. So you may find that probably this person found a way to bypass everyone and present documents that may appear legitimate. And even when we do the relevant due diligence, they appear legitimate. Then up until when there's a default is when now everyone comes out to say that probably this was ancestral land and things like that. So I'd like to say it is not intentional that we end up in that situation. It is unfortunate, and there are crafty people out here, and people will do anything to get easy money. So it just calls for everyone to be more diligent in what they do. Thank you.
Thank you so much. Steve would like to add to that.
Yeah, no, I just wanted to add to that and to say that, yes, that issue is quite common, that one family member maybe steals a match from the others and so on. And that one would be very difficult for a bank to mediate in that kind of, to go into mediation, because unless the family members are offering to some sort of solution as to how to pay back the bank, it becomes a very difficult issue on the side of the bank. So if you are advising the bank, you may find it, unless the bank just feels some sort of sympathy for that situation, and exercises some sort of, forgiveness. But otherwise, the bank will try and realize, its security. But in a situation where, let's say, it's a group ranch, for example, let's say it's a big communal property and some people have done the same thing, you may find that in that circumstance, it might be a bit different because of the number of people involved and the kind of interests and so on. And the bank may feel that maybe for reputational reasons and others, they may not want to be seen to be acting against community interests and so on. So in that sort of situation, mediation is more likely to happen where the interests, the bank feels that it has a bit more to lose, and then in that instance, they can say, okay, we can sit down with the community members, with the aggrieved members, and try and arrive at a solution. Do we give you back some of it, keep some of it? Are you able to organize yourselves to buy it back from us, and so on and so forth? So in that sort of situation, you could successfully mediate it.
Thank you for that. I would like also to add, before the bank gives a loan, there are several processes that take place. There's a surveyor who sent sometimes, there's a valuer who sent. So when they come to the land, if there's someone, they can ask questions at that point, also on why the bank wants to value their land. And the other issue is also we may need to teach our people back at home, if there's a property that is communally owned or it's ancestral, we need to have several people holding the land in trust. Next question, there's a gentleman in front.
Good afternoon to the panelists and also my fellow attendees. I am interested in something related to the challenges that mediators face in banking disputes. And I think Mr. Maloa has alluded to it. And I'd like to hear from Mr. Maloa and Madam Malesi, which is that I understand that the whole mediation process, from the moment you give the introductory remarks as a mediator, you welcome the people, involves what I like calling softening. You are softening the parties because they've come with hardened positions. You are softening them so that they can listen to one another, they can consider creative ways of reaching a deal. But typically, when one of the parties is the bank, the people who are in the room that you are softening are not the eventual decision makers. As you've rightly said, there is a bank credit committee that will make the decision. So you may actually find that the softening process has gone on and you even have a potential deal. And then one of the parties says, but I have to get the approval of a certain committee because of governance issues, and the mediation breaks down at that point. How do you ensure and secure the participation, the attendance of those decision makers? Because if the bank is not able to get the decision makers participating in the mediation, and of course they are busy people, they are dealing with dozens of clients or customers, then the mediation is not likely to bear fruit, especially where the stakes are high. What are your experiences? And to Hedaya in particular, the banks are very experienced in negotiating with their own customers. When there is an issue arising, the first step is they do the negotiation. And sometimes I've got the impression that the moment the negotiation fails, they don't have too much confidence that a third-party mediator is going to change significantly the dynamics of the conversation they've had with their customer. And so they may not deploy sufficient resources to the mediation process because they feel we tried it anyway, we are experts in negotiation. What will the third-party mediator do? What is your experience? And how can we get banks to be more confident in the mediation process. I do recall a few years back, Strathmore Dispute Resolution Center had a pilot project with Kenya Bankers Association, and they were working with banks. And the project worked for a few months, but I think the banks did not participate beyond a certain moment. Maybe they felt that spending a whole afternoon, one afternoon and another afternoon for the legal manager or the head of credit in the mediation process was too costly for them. Now that mediation is working, as we have listened to here, how can the banks practically deploy their high-level resources, especially to secure the difficult and challenging matters that they are dealing with? My colleague here also would like to ask a question, so I request he asks a question before the answer.
Can Stephen and Hedaya answer so that we don't lose track of the two questions?
And moderator, there's also a question at the back.
Okay, we'll come to that.
Okay, yeah. So Charles, to your question, the issue about this decision making in banks, you know, I always say that, you know, as a lawyer, I'm so happy that bankers exist, because you know, usually people say bad things about lawyers, okay, and then they remember that they are bankers. But you know, but bankers are trained in a certain way, and they have a certain mindset. And flexibility is not one thing that, at least in our context, bankers are not really known for flexibility. So they're very much about rules and procedures and, you know, ticking of boxes, and, you know, everything is done in a certain way. There are approval processes, you know, there are people, degrees of authority, and so on and so forth. So if the person who attends a mediation does not have the decision-making power, then already you have a problem, right from the beginning, because they will still have to refer to other persons who are not there, who have not been softened, as you said, who do not even have a relationship with the customer. Okay, they're just a statistic. They're a name. They're an account number. So the person making the decision is not meeting this person one-on-one. And so that is a major issue. It could be addressed by saying that, look, the person, if you're going to go into mediation, this person who goes has authority to compromise up to a certain, whether it's a monetary limit or whatever it is, okay? And we are not going to second guess this person. Now, you know, that's asking the bank to trust its officer. I don't know whether they're able to do that, but that would need to happen. And that is why I spoke about this being led by way of regulation, probably from the regulator, to drive the policy change or the process change by encouraging banks to do some of these things. Now, I don't know to what extent that is possible, so that the person negotiating has power to make a decision up to maybe a limit. If it has to go higher, then within the bank itself, there should be high probability that that decision will be ratified, okay, as opposed to it being kicked out of the door straight away. So there's a change of mindset, a change of procedure, and many things, and a relaxing of that rigid attitude. Now, the other thing, and I don't want to belabor this, but if you're in the credit department of a bank, your incentives are that you recover as much money as possible. You don't get rewarded for settling matters, right? And so even winning a litigation is, for you, is a positive. Whether the bank will recover the money or not is irrelevant, okay? But you took a case to court, you won the litigation, you have achieved your target, okay? So maybe, again, the incentives should be changed to say, how many matters did you settle? We're also going to measure your performance on how many matters were settled amicably, okay, as opposed to through litigation.
Hedaya, please handle the next.
Okay. I think one of the things that would really help is just being open-minded and and I understand, let me take it this way. You have a client who's been a perennial defaulter, for instance, you're in court, there's been negotiations, consents, and all that have not yielded much. Then you're sent to mediation. One of the things we can help in doing, and by we, I mean, say the advocates and KBA who are in the banking field, is to also sensitize our internal people and show them the need for mediation and the benefits, and just encourage them. I mean, if we've been in court with Victor here for 10 years and we've not yielded much, we can still try mediation and see what we can achieve in maybe 60 days. It doesn't harm that much. So that we can try to sensitize our members internally, and this is a clarion call to KBA, I hope they're here, so that even as bankers, we can be able to be a bit flexible. I agree with Advocate Maloa, we are not that flexible, and it is because of the regulations and the regulators and the people we have to answer to. But I'd also like to give a successful example where we've had a client who have been in court for, I think, almost 10 years, and eventually we went to mediation. And through the mediator and walking through the process, we were able to come up with an agreement that was registered in court. And the client is supposed to complete his payment, I think, sometime either in this quarter or next quarter, which is a successful thing. And it is because we were all open-minded and we were able to just show that let's give this thing another shot. I think that's what I can say for now. It just calls for open-mindedness.
Who else had a question after you? There's someone at the back. Yeah, after you. I'm picking out.
This side
then
too.
You.
Look this side too.
Who else was on this side? Then the guy in the blue shirt.